Hi guys, good evening and welcome to this very important YT live on writs under the Indian Constitution. Just half an hour ago we are done with articles 31, 31A, 31B and also 31C. Hi Vaishnavi, welcome to the YouTube live. How are you Vaishnavi? So today we are going to discuss Article 32, which is writs, which talks about right to constitutional remedies. So before proceeding to the class, I have certain very important announcements to make for all of you. Just give me a second. Allow me some time to switch on the chat window. Yeah, I hope that's perfectly audible and visible. So we are launching a very important batch which is known as Master Law for all state law entrance preparation. If somebody is preparing for TS Law Set, AP Law Set, Maharashtra Set, PU LLB and various other state law entrance examinations, you can enroll in the Master Law batch which has already went live on 27th of January. This is a 6-month batch and you can enroll in this by using my code Thrinath10 THRINATH10. You'll be able to get maximum discount, maximum instant discount if you're applying my code. Then we are coming up with a very important price hike on 1st of February. So we are going to increase the prices in our CLAT category very soon. So please make sure that you are subscribing to Unacademy Plus or Iconic ASAP. So now these are the prices of Unacademy Plus and Iconic subscriptions. This is very much affordable when you compare to other CLAT and other law entrance coaching. You can use my code Thrinath10 to get instant 10% discount. You can apply over here, need not pay this price. You can just use this, and this particular code is applicable not only in the CLAT category, but this code is applicable in judiciary, UPSC, UPPSC, SSC, non-technical banking exams, NDA, K12 and all the categories which are there on the Unacademy Learners application. And with this note, let us proceed with Article 32, which is right to constitutional remedies. Welcome to the session, everybody. If you can hear me properly and if you can look at the presentation, give me a very quick tech check. I hope I'm perfectly audible and visible. And also, please don't forget to hit the like button. Hello. Yeah. So we are done with 31C. So now we have 32, which is right to constitutional remedies. Now look at this particular article. Article 32 is considered to be the most important article of the Constitution because it provides the right to get fundamental rights protected, in itself a fundamental right. Please make this once again, good evening to you, Haindavi. Welcome to the session again. So guys, now we have certain fundamental rights. We have discussed 6 fundamental rights, and to protect these fundamental rights, protection of fundamental rights is also a fundamental right. This is a very important concept, I can say. Now, it confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. So now look at this, Vaishnavi and Haindavi and everybody who is there in this particular YouTube live. Now we have certain fundamental rights. Now, what if the fundamental rights are violated? Because fundamental rights are justiciable, they are enforceable in a court of law. What is a remedy which is available to the citizens of this particular country if his or her fundamental rights are violated? For that, we have right to constitutional remedies, and right to constitutional remedies in itself is a fundamental right. That is, right to approach the courts for the enforcement of fundamental rights is in itself a fundamental right. Next, the Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Hence, it cannot be abridged or taken away by an amendment of the Constitution. As I made a reference to this particular thing in my previous class when I was talking about Keshwananda Bharati versus State of Kerala. In Keshwananda Bharati versus State of Kerala, Supreme Court has actually created or invented a very important and new doctrine which is known as the doctrine of basic structure. So all the features of basic structure, they cannot be taken away by any amendment of the Constitution or by making any law. I hope this is clear for everyone. And Article 32 is considered as the heart and soul of the Indian Constitution. Now, Article 32 contains 4 important provisions. First one is the right to move the Supreme Court by appropriate proceedings for the enforcement of fundamental rights. This is a very, very, very important component because in a country like India, where we have independent and integrated judiciary, so in our integrated judiciary, all our cases go through a process of appeal. First, you have to approach the subordinate courts, then you have to go to the High Court, then you have to go to the Supreme Court. But if the fundamental rights of citizen are violated, then he or she can directly approach the Supreme Court and not necessarily by way of appeal. Okay, if you remember, in India there are two types of constitutional courts. First one is High Courts and second one is Supreme Court. So you also have the option of approaching the High Court in the first place, but Supreme Court, being the guardian and custodian of fundamental rights, if any of your fundamental rights are violated, you can directly approach the Supreme Court. Next important thing, the Supreme Court shall have the power to issue directions or orders or writs for the enforcement of any of the fundamental rights. So now what are these writs or orders or directions? We are going to talk about them in the next slide. Next thing is that another important provision. Parliament can empower any other court to issue directions, orders and writs of all kinds. And what do I mean by any other court? Any other court does not include High Court, because already under Article 226, High Courts have been conferred with writ jurisdiction. So High Courts can issue writs under Article 226 and Supreme Court can issue writs under Article 32. So what do I mean by other courts? Other courts ka matlab hai subordinate courts. As of now, subordinate courts are not recognized as constitutional courts. But if Parliament wants to give this particular writ jurisdiction to subordinate courts, Parliament can do that by enacting a very specific legislation for the same. Next important question. The right to move the Supreme Court shall not be suspended except as otherwise provided by the Constitution. A very important exception to the writ jurisdiction. Now, if any of your fundamental rights are violated, to move the Supreme Court is your fundamental right and it cannot be suspended except if there is a specific provision which is there in the Constitution. So what is the provision which is there? That is there under national emergency. If a national emergency is invoked, then the fundamental rights can be suspended. So Article 32 can also be suspended, which is provided under Article 359. Article 359 talks about suspension of fundamental rights during emergency. I hope these four provisions are clear for everyone. First thing, you can move the Supreme Court directly for the enforcement of fundamental rights. Number two, Supreme Court has the power to issue writs. Number three, Parliament can empower any other court in India to issue writs. Point number four is that the writ jurisdiction of Supreme Court cannot be suspended except as otherwise prescribed in the Constitution. If this is clear, please give me a very quick yes or no in the chat window. Next, only fundamental rights guaranteed by the Constitution can be enforced under Article 32 and not any other non-fundamental constitutional rights, statutory rights and customary rights, etc. It's again a very important catch over here. Now, what are non-fundamental rights? We have constitutional rights which are there, which we discussed in our previous class, like right to property. Then we have statutory rights. So statutory rights are those rights which are given by law. Now let us say RTI, right to information, is a statutory right. It is not a fundamental right. What are customary rights? Customary rights are those rights which come to you as a tradition. Especially, we see customary rights under Hindu law and a lot of other things. Now, if any of these rights are violated, Supreme Court will not entertain this in the first place. You can go it through appeal. So if your statutory right is violated, then go to the High Court. Okay, go to the lower court. Then, if you are not satisfied with the judgment of High Court, then you can come to the Supreme Court. But here, to approach the Supreme Court directly, it is only for the enforcement of fundamental rights. Very good, Vaishnavi. Writs are borrowed from United Kingdom, as we discussed in our initial lessons. Okay, so now the writ jurisdiction of Supreme Court is only for the enforcement of fundamental rights. I hope this is clear for everyone. And very important provision and very important legal maxim over here is that the violation of fundamental right is sine qua non. That is an absolutely necessary condition. Only and only if the fundamental rights are violated, then only you can exercise the right which is conferred to you under Article 32. If your fundamental rights are violated, you can approach the Supreme Court directly under Article 32 of the Indian Constitution. I hope this is clear for everyone. Please make sure that writ jurisdiction can be issued only for the enforcement of fundamental rights for the Supreme Court. For High Court, High Courts can issue writs for various other things like constitutional rights, statutory, customary rights, which we are going to discuss in our High Court chapter. Then the violation of fundamental rights is sine qua non, which means only if fundamental rights are violated, you can approach the court. I hope this is clear. Now, what are these orders or directions or writs which can be issued by the Supreme Court for the enforcement of fundamental rights? There are five kind of writs. These are not exhaustive but illustrative, because in the Constitution a word is used, including the writs in the form of habeas corpus, mandamus, prohibition, certiorari, and quo warranto, which means any other order can also be issued by the court. But these are five important writs which are there. First one is habeas corpus. What do I mean by habeas corpus? First thing you have to understand, if you are a regular attendee of my classes, you will understand the meaning of corpus. So corpus का मतलब है body. So corpus meaning is body. Habeas corpus is to present the body before the magistrate. If you are arrested by the police within 24 hours, excluding the travel time, you have to be submitted before the magistrate. It might be anything. You might have committed the crime or you might have committed the offense or not. That's a different thing. But if you are arrested, you have to be submitted before the magistrate or before the court within 24 hours. So if that particular body, okay, body doesn't mean dead body over here, the person, if that particular person is not submitted before the court, then court issues the writ of habeas corpus. Habeas corpus is to present the body. Dear state, present the body of the accused in the court. That is what is the writ issued by Supreme Court. Next one is mandamus. The literal meaning of mandamus is we command, okay, or do your duty. If any of the public official is not doing his duty, because of which the fundamental rights of a citizen are getting violated, then Supreme Court issues a writ to the public official. Dear public official, mandamus, which means do your duty, or we are commanding you to do this particular duty. Third important thing is prohibition. So prohibition is, complete prohibition of an order, cancelling a particular order which is issued by the state. Fourth important one is certiorari. So certiorari is a right which is available to the Supreme Court against the lower courts. Now let us say there is a lower court, a subordinate court, which is dealing a matter with respect to fundamental rights. Now lower courts are not entertained to deal matters with fundamental rights because they are not constitutional courts. Only High Court and Supreme Court can deal with that. In those cases, Supreme Court is going to quash the order or quash the proceeding which is there before the lower court and take the court on take that particular case by itself. That is known as certiorari. So certiorari is quashing the order. Next one is fifth important, which is quo warranto. So what do you mean quo warranto is by what authority? If any of the public official is holding a office, if he is not competent authority, then Supreme Court asks, by what authority did you appoint this particular person? So quo warranto is by what authority. So these are five important writs which are issued by the Supreme Court for the enforcement of fundamental rights. However, Supreme Court can issue some other orders as well in order to enforce the fundamental rights of citizens. I hope this is clear for everyone. Is this clear for everyone? Please give me very quick yes or no in the chat window. Yeah, very good, Vaishnavi, very good, Haindavi. Just a very quick revision, you can just go through it. It's very simple. 32, these are the five writs which are there. Just remember these things. This will really suffice for your all the upcoming law entrance exams in India. Okay, so with this note, I just want to inform another thing, that if you are planning to take an Academy Plus subscription or Iconic, then you can use my code Thrinath and get max on this. Okay, so Vaishnavi also, mandamus cannot be issued against President and Governor. No, they cannot be issued, Haindavi, because they are not public officials. They are constitutional heads. They are not public officials. Okay, I hope this is clear for everyone. So guys, we are actually done with most of the fundamental rights. Okay, now in the next class, that is tomorrow, we are going to discuss exceptions to fundamental rights. That is under Article 33, 34 and 35. We're going to discuss these three rights in our tomorrow's class. With this, fundamental rights will come to an end. Okay, fundamental rights, as I promised you, I'm going to close fundamental rights by the end of this particular month. And after completion of fundamental rights, that is tomorrow is 30th, right? On 31st, we will be having, on 31st, let us not, do anything, in the sense, we will not be doing any academic thing. How about doing a revision of the entire thing, or we'll keep an AMA session? How about revision or AMA or something of that? And I'm not going to do anything on 31st. I mean, I'm going to take a YouTube live, but we are definitely not going to talk about these things. you guys can suggest me in the in the comment box after the end of this particular live. And everybody who is there in this particular YouTube live, all the 7 people, please hit the like button. It means a lot to me, because I'm putting in a lot of efforts to deliver these classes to all of you absolutely for free, completely free of cost. Anyone and everyone who has an internet connection and a mobile phone can attend these particular classes. Okay, revision. Chalo, हम करते हैं revision. On the app or somewhere, we'll try doing revision. एक class fundamental rights का loss. We are going to complete entire fundamental rights in one session on 31st of this particular month. So, or we'll try doing this thing. Let us complete the entire constitution, then we'll go with that. Okay, so please hit the like button. Everybody in the class, please hit the like button. बढ़िए, जल्दी से जल्दी बढ़िए उस likes को. Hit the like button very soon. Thank you very much, guys. So with this note, I am just ending the class right away. I'm looking forward to seeing you all tomorrow in my classes. Bye bye.